Hi everyone, it's Mark and welcome back to our video newsletter. In this video I want to talk to you about how the voluntary admission process of the Baker Act can and does get abused. So let me just share a scenario with you. It was a question that was asked by a mum who had called us just very recently about her adult child who was taken to a Baker Act facility involuntarily as opposed to voluntary. They went there involuntarily, and then right as the 72-hour window was about to end, their loved one was asked to sign voluntary admission papers. So she said, well, what does that mean? Okay, so let me explain that to you, okay? And I know this stuff is very complicated and convoluted, so I'm going to do the best I can, okay? And as you know, I love answering questions, so if there's something here that's confusing about what I'm about to share with you, let me know. I'll do another video. So they were taken there involuntarily, okay? And I've talked about how that can happen, but they went there and they were being held for 72 hours. And then right as sort of in the last couple of hours of that 72 hours when they were supposed to be released, in fact, the mother had been told by the facility they were going to get released. The facility had their adult child sign documents, okay? And what they had them sign was voluntary admission papers. In other words, they had them sign a document that says, I am going to agree to stay. And the mother said to me, well, what is that all about? What does that mean? So let me tell you what it means. So the facility held them for 72 hours, okay, and based on what I'd heard, their loved one didn't even meet criteria, so they shouldn't have even been held for 72 hours, but because nobody's watching the facilities and, there's no oversight, they maxed out the amount of time they could hold the person. And then right when they were supposed to release them, they had the person sign documents that said, we're agreeing to staying. So what does that mean? It means that the 72-hour period is now extended, okay, basically until the person revokes consent. In other words, says, I want to leave, okay? And so what has happened is the person is there, they're stuck there, and no one even knows they're there other than the family and the facility and me, but nobody with authority like a judge to release them knows they're even there. And so basically the person has fallen into a black hole and they can't get out. They can't get out. And so, these facilities, they're really good at navigating through the Baker Act statute. Chapter 394, and you've seen me hold this thing up a bunch of times if you've seen any of my videos. It's real complicated, but these guys know how to work this statute, okay? So I'm here to tell you, first of all, you should never sign voluntary admission papers, because once you do, you're stuck there until you revoke that consent. So basically what happens is the person went there involuntarily. They were supposed to get out. And the facility, wanting to sort of milk the situation a little bit longer, bill the insurance company more or send the family another bill for services rendered, said to the person, why don't you sign this document? You'll agree to stay. You still need help, right? So what would have happened if they hadn't have signed the documents? Would the facility have released them? Probably not. You know why? Because while I can fight to get you out, the facility can fight to keep you. They can go to court just like I can, and they can ask a judge for permission to keep you, potentially up to 6 months. And if you don't believe it can happen, I'm here to tell you that it can. I've had that call from somebody who was stuck in a facility, had been court ordered there for 6 months. Almost impossible for me to get them out after that. It's too late. Okay? So look, this is how this thing gets abused. They went there involuntarily. 72 hours was about to end. They had the person sign documentation. They didn't tell them what they were actually even signing. And now they can't get out. And now they can't get out. And they've agreed to stay there. So no need to go to court, right? The facility doesn't have to get a judge's order. You've agreed to stay. Okay? So look, this is just one of the myriad of ways this Baker Act statute gets abused, okay? And it's one of the myriad of ways that I can help you, okay? Because consent's supposed to be voluntary, okay? You're supposed to know what you're signing. With that said, okay, feel free to reach out to us. I don't charge for a consult. If you have any questions, either shoot me an email, mark@bakeractattorneys.com. Go to the website, send me a question, and listen, take care, be safe. See you soon. Bye-bye.